'cause you can't, you won't, and you don't stop. Or when you can't, you won't, and you don't stop. With the basic characteristics of the Australian legal system outlined, the next step is to look at how things evolved the way that they did, and in so doing to give us an understanding about why certain governments have certain powers, and also the role of common law and judge-made law in our system. So we're going to look at the historical development of our legal system to try and reinforce those two key points. So how do we end up with this legal system? Okay, well, there's two core ideas that I'd like to cover. One is the idea of how was our legal system established. Now, that comes back to the arrival of the British, who didn't recognise the system of tribal laws and customs that were in place with our First Nations people. Okay. So because they didn't recognise that at the time, they actually occupied under a principle of law called terra nullius. We won't go into all the detail of how that operates. It's probably beyond the scope of our course, but that had a big implication because it meant that from our legal perspective, there was no established legal system in place. And in fact, they established martial or military law was how the country was first established because, of course, we were a penal colony. Okay, so that meant that the commanders of the Army and Navy were in charge of how things operated. Gradually, as development continued, what we start to see is the colonies, as they then were, wanting to have self-government. And so we start to see the New South Wales Act of 1823, British Parliament allows for Australian courts by the late 1800s, etc. Okay, so at this point, what we have is a series of colonies still subordinate to the UK and an unrecognised system of law that was in place that was incorrectly treated as not being there. So, two key events to think about into where we end up. One was federation. What happens in federation is the colonies come together and form the Commonwealth. So that means that the colonies become states and retain some power. So now we have two lawmaking authorities. The states have lawmaking powers in some areas and the Commonwealth in others. Okay, so neither government can make any law it wants to. There are limits on it. If there's any conflict, the Commonwealth law overrides states' law, provided it has the power. Okay, we'll come to what that means, but it's set out in our Constitution. I think the other important factor to think about is that the High Court actually revisited this idea of the principle on which Australia was founded and actually said it was wrong. Okay, so what we have here is an example, very major example of common law at work. Okay, so it shows how the Commonwealth, and we can argue it took far too long, but in the end it became that the law was flexible and recognised the true state of how it was, of what was done wrong back here. Okay, so it shows that the law can change, and it also shows how judges make law, okay, through revisiting principles and interpretation. Okay, so there's two kind of really big examples of things that are important to the Australian legal system. How the common law can change fundamentally what we know the law to be through judge-made law, not parliaments, and also the importance of recognising federation and the different powers in different bodies that we have in the states. We have a federation. The Constitution says how governments share power. That means, under the rule of law, governments can't do what they want. There are limits on their powers. And that's that's what we mean when we're talking about jurisdiction. Like, what's the limits of their power? What's the jurisdiction? What's their authority to make law? Now, within so we have the Commonwealth government and we have the state government, and within each of these arms of government, there is a legislature, an executive, and a judiciary. So we have, for instance, next door, we have the state legislature, okay? And in 1 William Street, Big Willie, across the road, we have a lot of the executive sit there. And uptown is the judiciary. But we have the legislature in Canberra, with a lot of the executive in Canberra for the Commonwealth, and the High Court of Australia is in Canberra. That's where they tend to sit. So what you can see is it's a kind of complex system when you start putting it all together, particularly when you recognise that there are 6 states and 2 territories as well. Whew. So now I've said, okay, we've got the Commonwealth government and we've got the state government, and they share power. But what powers do they share? Well, that was agreed under the Australian Constitution, which came into force in 1901. And we're going to deal with 3 key concepts, right? We have exclusive powers, which are powers that were given only to the Commonwealth government. We have concurrent powers, which are powers held by both the state and the federal government, and they can make laws. They can both make laws around those things. And then there are the residual powers. So what are the residual powers? If it's not named as an exclusive or concurrent power, it's a residual power. And so the power to make law for that topic rests with the state alone. And the federal government can't make laws about those topics. So in terms of exclusive power, we can see things like, raising an army. A state can't raise an army. It's the Australian dollar, not the Queensland dollar or the New South Wales dollar. Okay, so hopefully you get the idea that there are some exclusive powers given to the Commonwealth that kind of makes sense. If you want to have an army, you want to have an Australian army. Then there are this area of concurrent powers. Mainly, a lot of them are set out in Section 51 of the Constitution. Both governments can, for instance, tax people, have laws around marriage, banking, external affairs. We won't go into detail about what they are, but the way that operates is, while both the Commonwealth and state can make laws around those areas, if there's any conflict between the laws, the Commonwealth prevails, right? But only around the concurrent powers. If it's a residual power, if it's a topic around education, crime, health, transport, then the states have the power to make that rule, and the Commonwealth can't. So even if the Commonwealth made a rule, it wouldn't apply. Called ultra vires in Latin, outside the power basis. Okay, so this is an example of how it works. Some powers only the Commonwealth has. Some powers are shared, and the Commonwealth laws will prevail if there's a conflict, and some powers only rest in the states. And so that's what we've tried to set out in this slide, right? There's this idea of exclusive powers. The topics that are not as clear are those that are in Section 51, which are concurrent powers. If it's not in 51 or an exclusive power, then it's under the authority of the states. If there's a conflict between the state and the federal government around a concurrent power, right? Section 109 of the Constitution says that the Commonwealth will prevail to the extent of the inconsistency. So neither the federal nor the state government can make any laws they want to. They are subject to the rule of law. And if you want to challenge the validity of any legislation, you go to the High Court, who decides these matters. That's a very brief introduction into the Australian legal system. We're going to go a little bit deeper, looking at the arms of government within each of the state and the federal government in the next series of slides and videos.